次の動画では、今回行われました国際模擬仲裁、それから調停でですね、実際に、仲裁人、それから調停人、それから当事者の代理人をやりました、担当の演技をしてくださいました、弁護士たちとパネルディスカッションをしておりますので、それをご覧いただきたいと思います。登場人物としては、私がモデレーターを務めて、仲裁人、第三仲裁人チェアをやっていたスイスの弁護士であるチャールズ・アダムス弁護士。それから、調停人を務めましたドイツの弁護士である、シーグフリード・エルシング弁護士。それから、オートソフト側の代理人を務めました、知的財産を、中心とする、プラクティスをしております、弁護士であるアレクス・チャチキス弁護士。この3名を招きまして、ディスカッションをしました。ポイントとしては、まず第一に、アービトレーションメッド、アービトレーション、アーブメッドアーブ、およびメッドアーブの活用と比較ですね。それぞれについて費用手続きの重複、すなわちアービトレーションとメディエーションの手続きの重複になってしまわないのかというような点。それから紛争解決としての効用はどうなのか。紛争解決条項を作成するときに、このようなアーブメッドアーブ、あるいはメッドアーブをどのように取り入れていくものなのか。それから取り入れるときにどういう点に注意をしなければいけないのか。そのあたりをディスカッションしています。2番目に、知的財産関係の紛争解決における国際 ADR、仲裁、調停の効用について議論をしています。本件のケーススタディでは、知的財産関係の紛争ですから、そのようなディスカッションをしています。知的財産紛争解決のための ADR において、選任すべき仲裁人、調停人の資質、専門とするプラクティスエリアなどの要素、こういうものはどのように加味していくべきなのかというようなことを、質疑応答しています。それから、知的財産特有の経験や能力を優先すべきか、契約、実務など、生じ紛争解決としての経験や能力を優先すべきかどうかというようなファクターについても、議論しています。また、知的財産紛争解決用の仲裁条項の作成方法やドラフトのポイント、あるいはインハウス、つまり企業内の弁護士の役割などについてもディスカッションしています。第3に、スタンダードエッセンシャルパテント、標準必須特許と言われる紛争解決などのプラットフォームとしての日本国際紛争解決センター JIDRC、あるいは、日本国際、調停センター JIMC 京都の活用可能性、それから戦略などについても踏み込んだディスカッションをしていただいています。スタンダードエッセンシャルパテントの複雑性、準拠法、ライセンスの数などを鑑みてですね、クロスボーダーの紛争解決における仲裁、調停の効用、あるいはコストの節約になるのではないかというようなポイントについてもディスカッションしています。で、第4に、このような1、2、3のような要素を考慮して、代理人としては現実にユーザー側としてどういう弁護士が望ましいのかというような話も、行っております。すべて英語のディスカッションになりますが、こういうポイントについて、興味深いディスカッションがされていますので、ご覧いただければと思います。
ここからですね。So shall we get started? Thank you very much for your excellent play. I really like it. Personally, also, really enjoyed it. Actually, for the arbitration chair and a mediator and represented with the very strong IP litigator. So we got some very interesting questions from the audience. First of all, regarding why the old soft side kind of accepted the offer of the settlement negotiation, although that looks quite strong, and then not the motivation. But I explained a little bit. Old soft has also kind of a weak point, like a contractual argument and concealment. It's tough to prove, as the Sigrid mentioned, and also they have a business interest, something like that. So then they got into the Arb Med Arb things. And so the audience question is what's the advantage for the users for using such Arb Med Arb or Med Arb Med combination? So I'd like to have the Charles Adams comment and the Siegfried, and especially some questions come up from the audience, like if you do arbitration, mediation and arbitration, that could looks like redundancy or a double cost expense and more timing, something like that, more burden on the parties or something. So then, what's the answer? What's your opinion, Charles? Could you please, from the perspective of the arbitrator or practitioner?
I actually would have a concern about a provision which made it mandatory that one go through mediation before proceeding to arbitration, for two reasons. First of all, it does create the possibility of delay and basically obstruction of a dispute resolution finality if mediation is made a precondition of arbitration. Even worse would be a provision which had three stages. One sees this from time to time. First of all, the parties will negotiate in order to find an amicable solution and will escalate within their company to a higher and higher and higher level. Then, if this doesn't succeed, there will be a mediation. And this will take some number of months. And only then, if there still is no finality, will there be an arbitration. And the arbitration will produce a final resolution of the dispute. But by now, months, if not years, have gone by, and the expense will have been considerable. My own personal preference would be for a provision in the agreement that provides for international arbitration and for a final unappealable decision. The parties know perfectly well that it is open to them at any time, if they prefer, to resort to mediation, and they simply advise the arbitration tribunal, as was the case in this mock proceeding today, that they will attempt a mediation before the arbitration can resume. But certainly it ought not to be made a contractual precondition to arbitration.
Thank you, Charles. Siegfried, could you pass any?
Yeah, we are here to give you options, and you heard Charles explaining one option. He's right, it can, if you agree on a Med Arb structure, as I had suggested in the mock, that can lead to delay. Let me just give you the other side of the coin, which is, to be honest, my view. If you structure the Med Arb clause properly, you could avoid the disadvantages. There must be a clear timing in the clause. So the window of opportunity, the time that you allow yourselves for mediation must be clearly defined and short. 4 weeks, not more. It must be structured in a way that you escalate quickly. Negotiations or mediations, mediated negotiations should not start on the operative lower level. It can be escalated up to the top level. Then you have, of course, a cost, but it's calculable. The advantages of a mediation are clear. The costs are limited. Mediation must also be properly prepared, that's clear. But compared to the costs of an arbitration, even up to the stage that we have seen now, the procedural meeting, are clearly higher. They can be unavoidable, but consider it, it's an option you have. It might be worth trying if you put into the Med Arb clause the correct language, the safeguards that avoid what could happen, I agree with Charles, avoid conceivable disadvantages.
Thank you, thank you. Yeah, it's really sounds like the depending upon the nature of the case, and also depending upon how and whether the both parties could have the common interest or something, including the future future business. But I really appreciate the comments. But anyway, we have very limited time, and then I really personally would like to continue to this discussion, one day, but that could not be possible. So next question from maybe to Alex and other, the Charles and the Siegfried. So especially regarding this case type of IP-related disputes. That's a technology included, but on the other hand, that's also kind of a contractual commercial dispute, but mainly the AI and all, automatic, the vehicles, things, and technology and patents included, especially the US litigations. The kind of strategy making would be very critical. So in such case, my question is what's the critical factors or elements or qualification for possible arbitrator? I mean, if your clients or users which are involved in this type of disputes, whatever litigation or arbitration, but especially for the arbitration, they need to appoint the arbitrator. So what's your suggestion, Alex?
It's a good question and a very difficult problem. And I'll give a concrete example. I was involved in an arbitration between a German company and an American company. The German company didn't want to have a litigation in the American courts, quite naturally, and the American company didn't want to have litigation in German courts. So they agreed on French law, covering a contract for US patents. So this is a dilemma when it came to picking arbitrators, because what person is an expert on French law and on US patents? Such a person doesn't exist. So there are a number of solutions to this. One of the solutions is anticipating this problem ahead of time and writing an arbitration clause that includes some provision for an expert of US law, expert of US patent law, to be part of the arbitration or part of the arbitral panel, but not one of the three arbitrators. Another way of doing this is once you're in the arbitration, agreeing with the other party that you've faced this problem and agreeing to have a consultant to the panel of a neutral third-party patent expert. For example, there are a number of retired federal judges in the United States who know patent law quite well, some who practice primarily in the scope of patent law. Somebody like that who would be perceived as neutral to advise the panel. But it's a very difficult dilemma that you face every time there's a license dispute over patents.
Thank you. That's very helpful. So, Charles, you have any thoughts on that?
My only thought is that international arbitration clauses should always be kept as simple and straightforward as possible. The best solution, actually, is that each of the institutions that sponsors international arbitration, the International Chamber of Commerce, the London Court of International Arbitration, the Singapore International Arbitration Center, etc., have little booklets with their rules, and at the end of the booklet there is a model clause, which is a simple, straightforward statement that recites, in the case of the ICC, as follows, quote, this agreement, any dispute arising out of this agreement will be fully and finally resolved by international arbitration under the rules of the International Chamber of Commerce. The number of arbitrators shall be 3. The place of arbitration shall be Tokyo. This agreement is governed by the law of the state of Delaware, USA. So there are only 3 blanks to be filled in: the place of arbitration, the number of arbitrators, and the governing law. The rest is simple. And I would be very concerned about adding to the arbitration clause anything that stipulates that the arbitrators will have to be expert in shrimp farming, for example, if the dispute arises out of a shrimp farming license agreement, or that the arbitrators have to be fluent in whatever language it is, because that simply provides an opportunity for whichever party wants to resist and obstruct and complicate the arbitration to have a separate litigation about the fact that Mr. So-and-so is in fact not an expert in shrimp farming, or that Mrs. So-and-so is in fact not fluent in whatever language it is that is required. It's an unnecessary and dangerous complication.
Thank you. So it's reminding me of I've seen a lot of kind of a strange arbitration clause, even prepared by the Japanese big corporations. So that's sometimes have a very unclear provision or something. So that's triggering some sort of drafting issues, and could be related to the in-house lawyers or legal department staff's role, because we have many in-houses today. So Siegfried, do you have any comments related to the Charles point and also the role of the in-houses as well?
Yeah. Yes. First of all, I can only echo, keep it simple, avoid doing too much drafting unless you really have to. Pathological arbitration clauses must be avoided. However, even based on a standard clause suggested by an institution, established institution, you would have flexibility. What I said about flexibility in mediation applies to arbitration as well. And just to illustrate quickly what it can mean in the context of IP, I was arbitrator not so long ago in a substantial dispute involving standard essential patents. As you know, standard essential patents, there are some 20,000 patents used in this mobile phone. And they are not owned just by one company. There must be licensing fees paid. And in this case, there was agreement between the company that had the patents and the user about the principle of liability. So they had a license agreement, but they could not agree on the substantial royalties. There must be, as you know, fair, reasonable, and non-discriminatory. And they, based on a standard clause, delegated, charged, and tribunal delegated that task to a tribunal. And we could be very flexible. Confidentiality had to be complied with, the use of patent law expertise. So even based on a standard clause, you can be flexible in an arbitration. And arbitration, I think, is also a wonderful means of dispute resolution in these complex disputes involving SEPs, standard essential patents. Now, the role of in-house counsel, Yoshi reminds me. I mean, as outside counsel, we are service providers. And we had here on the panel the company representative and two outside lawyers. As in-house counsel, you determine what is being done. You take the advice. The decision-making function is with you and your management. That is important. If you have a significant dispute, I sometimes see that the role of the strategy and very important decisions are entirely delegated to the outside counsel. That's perhaps sometimes good for outside counsel. It's not necessarily good for everybody else involved. I would like to use this opportunity from the vantage point of an arbitrator to appeal to you to see your role as in-house counsel more actively in an arbitration. Make sure you attend, of course, all hearings, in particular the organizational meetings, and you use your influence. And internally, that means also an appeal, and we at ORIC try to do that, that we are as open and as communicative as we can with our clients when it comes to making tough decisions about strategy and costs. That would be my comment.
Thank you, Siegfried. So your comments actually included the SEP disputes, SEP disputes. So that's could be related to the our future utilization of the Kyoto Mediation Center and even the Dispute Resolution Center here, because the SEP dispute is quite cross border, about like jurisdiction, something. So, I should not step into too much the substance of the asset dispute, but I'd like to invite the Alex Chachki's view on, especially for the purpose of the utilizing and maximizing the utilization of the mediation center in Kyoto and dispute resolution in Tokyo or Osaka, whatever. So what's your view? For example, the asset disputes resolution could be appropriate subject, and then what else? And you have any idea or thoughts how to utilize for such facility and institutions?
Yeah, I think that kind of mediation center is a great resource for resolving something like standard essential patent disputes because of the extreme complication and the possibility of becoming overwhelmed in cost. So standard essential patent disputes often turn to questions of what the entire industry is doing in terms of licensing similar patents. So right now, many of you are aware there's an enormous litigation going on between Qualcomm and Apple in the United States. And in that dispute, they've probably served a subpoena on 20, 30, 40 companies, maybe some of the companies in this room. That's the kind of thing, the kind of cost and complication one might be able to reduce by using mediation as an option.
Thank you very much. Yeah, that's actually as Eric, we have some lawyers who are very expertise on the SEP disputes, but mainly the IP lawyers and the antitrust lawyers kind of combination. So then my question to the panel is what's your advice to regarding what kind of lawyer or what kind of law firm you should retain? The answer should be Oric, but that's beyond that. But what's the elements and the factors? What are the key points you should consider when you retain the lawyer? So you have any comments, Charles?
International arbitration is a very special discipline in the sense that it happens all over the world, and there are no requirements that are imposed as to the counsel who are retained to advocate and to prosecute these cases. For example, if the arbitration clause provides for arbitration in Singapore, that does not mean that the counsel in the arbitration has to be admitted in Singapore. The counsel for the arbitration can be any one of you or any one of us. There is no special requirement or qualification. Now, there are some practical considerations. The statistics, the most recent statistics of the International Chamber of Commerce suggest that about 70% of international arbitrations are conducted in the English language for various historical reasons. And that would suggest that counsel, in order to advocate in international arbitration, orally and in writing, needs to have a strong mastery of the English language. There are arbitration clauses that provide that the arbitration is to be conducted in Spanish. In that case, it makes sense that the counsel who's retained by the company to represent the company in the international arbitration be very fluent in spoken and written Spanish. But otherwise, really, it's a matter of one's sense of the capability, of the skill, of the determination, and of the track record of counsel for this kind of specialized discipline around the world.
Great. So Sigrid, you have anything?
I'd like to come back to the part of the question that related to the efforts which are underway to establish Japan, Tokyo, or Osaka as an even more important arbitration center. We know the current situation when, from a European vantage point, we look at Asia, Singapore comes into the view, Hong Kong perhaps, but it's more often than not Singapore. I have been, over the last 2 years, involved in a number of situations where there were arbitrations between Asian companies and European companies. Asian companies from a common law jurisdiction, European companies from a civil law jurisdiction. Contractual disputes where often the contract was governed by a civil law, continental European law. In all those cases, I was appointed by the European party, and there was a colleague appointed by the Asian party. When we looked at the options for the chairman with a seat in Singapore, more than once I heard the argument, the parties have chosen Singapore, and that indicates that for the chairman, they want someone with a common law background. It would be very nice to have another option, to have Japan, Tokyo, or Osaka, because then that argument could not be made. And it would be a more open situation. I don't think that the argument has much valid. If you choose Singapore as a seat, it doesn't mean that the chairman must be with a common law background. It doesn't, you know, there are Swiss lawyers who know the Singapore arbitration law and so forth. But the argument as a psychological observation is made, and against that background, I would only welcome if there would be an alternative in Japan to Singapore.
Thank you very much. Yeah, in addition to the language capability, but also for, like, as Siegfried mentioned, like the arbitration field is always kind of hybrid combination of the common law culture and civil law culture or something. So maybe I believe the law firm and the lawyer's role is to understand the communication for understanding such kind of a difference, and then grasp the interest from the clients, and then make a strategy. So that's my kind of a final word. But anyway, thank you very much.
はい。では動画をご覧いただきました。今回は国際模擬仲裁調停の動画を見ながらということで、第一の場面としては、仲裁準備会の模様、それから第2の場面として調停手続きの模様、それから第3の場面として、実際に仲裁、それから調停の仲裁人、調停人として携わった、登壇した人、それから代理人として登壇した人を含めてのパネルディスカッション、この3つをご覧いただきました。この解説と、それから動画に並行してスライドも表示していますけども、これをご覧いただくことによって、実際国際仲裁、調停がどのように進行し、またどのように活用されていくべきかということの一助になれば幸いです。どうもご視聴ありがとうございました。